Your Achilles appearing on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Anastasia Rakes. Ms. Rakes, can you please state your full name for the record?
Anastasia Rakes.
All right, first of all, Your Honor, we tried to take a plea last time and it didn't go over so well, but I did get a chance to go over the video with my client, go over the plea, and I believe she's ready to plea now. Now, I believe we have another matter that we have to discuss about the bond violation in which my client has a warrant. And whenever you want me
She does. Let's deal with the bond violation. I may not be taking a plea today.
Gotcha. Okay. First of all, Your Honor, my client indicates to us that she wasn't drinking.
She what?
She wasn't drinking.
This is already unusual. The judge signals immediately that a plea may not even happen today. Translation. The bond violation is serious enough that everything else just took a back seat. And that's never a good sign for the defense.
And honestly, I don't say this about everybody, but I do believe my client at this point. First of all, the blood alcohol level was 0.04. It was 0.04. If my client would have been drinking, especially with the problem that she has, it would have been way over 0.04.
This is where the defense argument goes off the rails. The lawyer is essentially saying, because my client drinks a lot, this low alcohol reading proves she didn't drink at all. That's a bold and risky logic leap, especially with a SCRAM tether involved.
It was only for that one day. If you notice that she went...
If she had been drinking, it would have been over that amount?
It would have been over that amount because my client doesn't know how to stop drinking. And she understands that she has a problem. That's just one thing. But if you notice that she went through Christmas, she went through New Year's, and I believe Thanksgiving, you had zeros all the way across the board. And if you remember this case, my client's the one that actually said, I don't want the breathalyzer because the breathalyzer is too easy to cheat, and put herself on this alcohol tether to show the court that she couldn't that she wouldn't drink. She indicates to me that she is a clean. She's obsessed with cleaning. And it is possible that those chemicals got to her tether. But in all honesty, Your Honor, dealing with the facts of the situation that we got in front of us, we got somebody that asked to be on something stricter to show the courts that she wasn't drinking. To address her problem, even more, to make sure that she's not cheating the court. We got somebody that has dealt with alcoholism for a long time in life. And like I said, when she does drink, she drinks a lot. And she understands that. And she's looking for help. She's searching for help. She showed the court that she's searching for help. So when she does drink, she drinks a lot. And the fact of the matter is, that's why that 0.04 doesn't. I can understand when she told me that I'm not drinking. I wouldn't have put my kid in that situation. I'm all he has at this point. And she's been responsible. She showed her response. She showed she's been responsible.
Notice how the argument shifts from science to sympathy. We're no longer debating chemistry. We're hearing about holidays survived, addiction struggles, and intent. It's less about disproving the violation and more about asking the judge for mercy.
Like you told one of my clients, the most major drinking holiday days that then came with Thanksgiving, the day after Thanksgiving, New Year's Eve. She showed that it's been nothing in her system. So I do believe it was an honest mistake. And I do believe that my client can't just drink one beer. And I honestly believe that. So, Your Honor, we're just asking that you give my client a chance. She showed you that she could go without drinking. I believe that violation. When was that violation, Your Honor? November? For December 13th,
December 17th
December 17th.
into the 18th.
But if you notice the alcohol level was dropping when it went into the 18th. So it went to 0.04 and it went lower. It went lower and lower each time. So it's not like she was continuing drinking.
Which cuts against the fact of thinking that it's a chemical. Because a chemical that wouldn't happen.
I'm not.
It would either remain or it would dissipate faster than the body would be absorbing any alcohol.
And that's why she didn't say she knew it was a chemical. She said that could be a possibility. But one thing she said, I know I wasn't drinking. I know I wasn't drinking. And for the fact of the matter, everything surrounding this situation, I believe she wasn't drinking. Now, even if we were to take that not to be true, what she said to me, I do believe we have a lot of mitigating circumstances to allow my client to stand out of jail. But I'm standing in front of you today that's saying that I really believe my client when she said she wasn't drinking. I seen the video of when she drinks. I heard the discussion. I heard the discussion that the witnesses had with the police that talks about when she drinks and how much she drinks that she just can't stop. So a 0.04, I can't see my client taking a sip of anything and stopping. I can't.
Response from the people.
I would think it up to your discretion with these sorts of things, as I always do. Like 0.04 to me is not nothing.
Right. How long has she been on the tether?
For about 2 months, maybe 2 months.
Pardon?
Yes, I've been on it like a month, 2 months.
And as I stated earlier, Yana, she's the one that was taking the breathalyzer and came in here and asked to be on the tether instead of the breathalyzer to ensure that she doesn't.
Here's what I'm going to do. You want this adjourned, Grant?
The bond violation. We were going to.
Go ahead. What?
We'd like it dismissed, but if we can adjourn it, Your Honor, then yes, please. We would like it adjourned, but I do know my client is ready to proceed with the plea, but if you're not at that point, then...
I'm not at that point yet. I mean, I'm not saying that I won't, but here's what I'm going to do.
This is the moment of truth. The judge makes it crystal clear. This was her warning shot. No more excuses, no more theories, no more second chances. One slip, real or imagined, and it's straight to 60 days. Would you feel comfortable walking out of court under that pressure?
I'm going to adjourn the probable cause and the bond violation. I'm going to adjourn it out to February 12, 2026, 9 a.m. And I'm just going to say it this way. What I really of right should do is I should put you in today. I'm not going to do that. Mr. Bird has convinced me not to do it. That is something that is against my normal practice, but I'm not going to do it. Well, don't thank me yet.
Okay.
Because normally you might spend a week, 10 days, get your help, do whatever. But now we're going to make a deal. I'm going to adjourn this out to the 12th of February. We have any event whatsoever. I'm not listening to any of that. I'm not listening that it might be a chemical. I'm not listening that something went wrong. I'm not listening to anything. You're just going to go in and you're going to do 60 days. Understood?
Yes.
So we'll put it up to that date. And continue.
Thank you, Your Honor.